Today, I have someone who I think is perhaps one of the most brilliant legal analysts in the country, Judge Andrew Napolitano. And I think that people can introduce themselves better than I can. So, Judge Napolitano, would you like to say a few words about yourself before we get started?
Oh, well, Christian, thank you for having me with you. I'm a lawyer, a former life tenured judge, and most people probably know I was at Fox for 24 years, where I was in front of a camera 14,500 times, which means a lot of your folks probably recognize my name or my face or my voice, but I'm happy to be on with you.
Yes, no, I appreciate it. So, when I think of the legal landscape in America, and I think of what has occurred over the past few months as of the shooting of this interview, the Dobbs case, and other things that have occurred as well, um, I like to go back to first principles. I think that, and you tell me if this theory is correct, Judge, that what we're seeing happen right now in terms of legal fights and cultural fights goes back to our legal and political system not recognizing the issue of first principles. And you've done quite a bit of writing about natural rights, natural law, and how these things are essential to the American experiment. And my thought is, if these things were followed more in our political system and our legal system, a lot of the controversies we have over whether it be abortion, over licensing, over all these different issues would be moot because they wouldn't be happening. What are your thoughts on that? And do you think that the legal system has strayed away from core foundational principles as a mechanism to conduct business? Or is this, yeah.
Well, the government came into existence by a bloody war of secession from Great Britain,
Mm,
during which the leaders of the revolution professed their fidelity to the first principles you were discussing, what Jefferson called nature's God
mm,
and nature's law, what St. Thomas Aquinas and John Locke referred to as natural law, and James Madison did as well.
mm,
So when I was teaching constitutional law, I would often say to students, well, if the states ratified a 28th Amendment that repealed the first saying Congress shall make no law abridging the freedom of speech, would we still have the freedom of speech? And those who believe in positivism, that the law is only what is written down by the lawgiver, would argue no, we wouldn't have freedom of speech. Those who believe that our rights come from our humanity, the natural law theory, would argue yes, we have freedom of speech, whether the Constitution recognizes it or not. And the whole purpose of government is to protect our rights. And so the government would have to protect the freedom of speech, even if there were no First Amendment, because in this hypothetical question, it had been repealed. So that's an example of the two different ways to look at this. But the ultimate first principle is that we have human rights given to us by the Creator, and they can't be taken away unless by our behavior we waive those rights. The highest of those rights is the right to live. The other rights are basically characterized in the Bill of Rights: the right to think as you wish and say what you think, to publish what you say, to petition the government for a redress of grievances, to defend yourself using the same means that the government uses to protect its own personnel and property, and that quintessential American right, the right to be left alone in the Fourth Amendment, the right to own property, the right to due process, to fairness from the government. These are all natural rights that the government must protect whether it wants or not. Immediately after the country was formed, the same generation, in some cases the same people who wrote Congress shall make no law abridging the freedom of speech, enacted the Alien and Sedition Acts, which did just that, made it a crime to criticize the government, and people were prosecuted for speech, for criticizing the government. So it is fair to say that no government, including the sainted Thomas Jefferson, recognized natural rights the way we understand them as inalienable. Jefferson wrote that in the Declaration. Now, I'm not picking out Jefferson. He's my favorite president. He came closest to recognizing natural rights. But for the government to recognize natural rights, it would have to emasculate itself of a lot of its draconian authority, including the power to tax.
mhm.
Taxation is theft.
Hmm.
Murray Rothbard tells a story about you're home one night and there's a knock on the door and you go to answer it and there's a guy with a gun. He says, "Give me your money." And you say, "Well, I'm going to call the police." He goes, "Don't bother. I am the police. I'm here to collect your taxes."
Hmm.
That's what it is. That's the mafia model. Give me your money or else. So that's what we've become accustomed to. It's an emasculation of our natural rights. Everybody in government takes an oath to uphold the Constitution, which includes the Ninth Amendment that articulates a defense of natural rights.
Hmm.
But there is no government in America that does this today. Some come closer. Every once in a while, the courts will write a decision that's based on natural rights. They don't use that phrase because, according to Justice Scalia, the late Justice Scalia, my dear friend, it's too Catholic and it would never get a majority on the court. So they call it substantive due process or fundamental liberties or pre-political liberties. They all mean the same thing. Rights that pre-existed the government, that don't come from government, that come from our humanity. Every once in a while, the Supreme Court, done so very recently, will articulate rights like that.
Hmm.
But the Congress doesn't, the president doesn't, state legislatures don't, town and city councils don't. They write whatever laws they want, they regulate whatever behavior they can, they tax whatever event they can get away with taxing.
Now,
Sorry, the answer is so long.
no, because this is very important. It's very important. It's very rich analysis, sir. So I have to ask this question then. We have I like to think of the government as a house. We've got the foundations, which is natural law, natural rights, man's ability to reason and being able to discover those things through our ability to reason. Then we've got the structure being everything that's supposed to spring forth. So the Constitution, things of that sort. We've got the roof and everything like that. Since the structure has deviated so far away from its foundations, what do you think is the sort of legitimacy behind, how do I say this in an eloquent way, behind political action? What I mean by this is that there are so many different visions that are trying to engineer and direct the movement of the structure towards a certain end. You got communitarians of all stripes that want to make a politics that centers around the common good, so to speak. You've got other people who want to make a politics that centers around the working class. All these different visions which deviate from the founding. How does the political structure survive this tug and pull? Because it's already violating its foundations.
No government can be relied on to restrain itself.
Hmm.
It's just against the nature of government. It's against the nature of the people who go into
Mhm.
government. People like Ron Paul or
Mhm.
me or you don't go into government. I was a judge. I didn't work for the government. I worked for the Constitution. The government may have paid my salary. That was sort of my cutesy response to my libertarian friends say, "You're in the government." Jefferson recognized this in two ways. One, the Kentucky and Virginia resolutions. He wrote the Virginia resolutions. Madison wrote the Kentucky resolutions. They wrote them anonymously because they were both in the government at the time. When the Alien and Sedition Acts were written, Jefferson was the vice president of the United States. He had no say in what John Adams was signing into law. James Madison was Jefferson's congressman and was in the House of Representatives. So they secretly wrote these resolutions, and the resolutions argued that when the central government violates its central charter, aka the Constitution, the states can nullify that violation. Now these two statements were written by the guy that wrote the Declaration, the guy that wrote the Constitution, who also wrote the Bill of Rights, nullification. So if there's a mechanism whereby the state highest court, Supreme Court of New Jersey, Court of Appeals of New York, Supreme Court of Alabama, they have different names, most of them are called Supreme Court, or a state legislature can negate what Congress has done when it violates the face of the Constitution, that's one way to restrain it. The other way to restrain it, and this was also suggested by Jefferson and never came to pass, was to sunset everything so that the government itself had to be reapproved. The Constitution itself had to be re-ratified once in every generation, which in Jefferson's day was 19 years.
Mhm.
Only something as radical as those two propositions will work. But the judiciary, even though it is independent and even though it is the anti-democratic branch of the government whose role it is to protect our lives, liberty, and property from the democratic branches, has failed. I wouldn't say miserably, but for the most part, it has failed to do so. Every once in a while, the judiciary slaps down the Congress and the president, but for the most part, certainly since the FDR years, it just goes along.
Well, Judge, I think we're at time, but thank you so much for coming for a chat. I really appreciate it, and I hope to have you come back.
It'll be my pleasure, Christian. We'll do it again
right.
soon. Thank you.
All right, thank you. Bye.